Okay, members, you're welcome to use electronic devices if you can do the needful. If there's any declarations of interests in respect of the business, now's the time to declare them. Okay, then members are content, we'll take the oral evidence session being recorded by Hansard. There's no apologies. Officials are attending via the Starley facility. Relevant papers, including the letter setting out changes to the Department's proposed amendments requested by the committee at the meeting last Thursday, are on pages 7 to 44. So can I welcome Dr. Veronica Holland, Head of Violence Against the Person Branch, Stephen Martin, Deputy Director of Enabling Access to Justice Division, and John Bradley, Head of Branch, Civil Legal Aid Reform from DOJ to the meeting. Again, this will be recorded by Hansard and transcript will be published on the committee web page. So we're first going to just deal with the Department's revised amendments, with the exception of those that relate to civil legal aid first, and we will deal with that then after we've disposed of the other amendments. The committee have obviously went through these. I'm not going to invite Veronica to talk us through because the letter is self-explanatory and members have an opportunity to consider the amendments that have been provided. I have just one question, Veronica. Clause 29, guidance on the data collection. If you can just elaborate for me why the Department feel it is necessary to remove the reference to the Northern Ireland Courts and Tribunal Service.
Essentially, the basis for that is that the Department would be given advice to itself. So the view from the draftsperson and from the Department is that it doesn't make sense for the Department to give guidance to itself. That's not to say that Northern Ireland Courts and Tribunal Service won't be covered to the same extent. They are part and parcel of the operationalisation task and finish group that is meeting at the moment, along with police and PPS. And whatever information is going to police and PPS in relation to the information that's to be obtained will also be shared with the Courts and Tribunal Service. But as I say, because Courts and Tribunal Service is a part of the Department, the Department would, as I say, essentially be given advice to itself or a requirement on itself.
And why is that same argument not relevant in the reference to training, where it cites the Northern Ireland Courts and Tribunal Service specifically on the bill?
I suppose in relation to the training, there was, the committee is obviously very keen that that is made explicitly clear, that there is a notice, that there is a mandatory nature in relation to that training, and that it be undertaken annually. If you don't have that reflected in the legislation, the concern from the committee's perspective would be that that wouldn't be covered. Okay.
Does it do?
So that is in relation to a duty as opposed to a more general aspect.
Okay. I'll bring in any other members then in terms of these amendments. Linda?
Just, I suppose, to clarify, it's not even a question, Veronica, but just to clarify the issue that was raised on Thursday around the DAPOs and DAPNs and the age at which those become relevant or applicable. And we had talked about whether it should be 18 or 16. So obviously based on the letter that has come from Nicky and the Department's own letter, and the fact that this is the case in other jurisdictions that it's 18, and that, I suppose, focus on other interventions other than giving young people a criminal record, I would certainly be supportive of keeping it at 18, and I think that's the right approach by the Department. So just to
I think there was also
that.
a concern in speaking with colleagues in some of the other jurisdictions, and I suppose would probably also be a concern from some of the voluntary sector bodies, is that if it is 16 plus, you're potentially putting 16 and 17, you're making them homeless and putting them out of their homes. So I suppose some of the concerns related to the fact that breach of the orders would criminalise them and bring them within the remit of the criminal justice system, and also that the impact that would have on them more generally. Appreciate, obviously, there is still the issue of the abusive behaviour, and that needs to be looked at. As we indicated, some of these things will be dealt with through youth justice input and work with individuals in that situation, as well as the potential for either non-molestation orders or occupation orders to be brought forward.
Yeah, and I think we've been very clear as a committee that this is not just a justice approach, that education has to be a crucial element of it, so that would hopefully address some of the issues around young people and the healthy relationship stuff. So thank you, Veronica. Thank you, Chair.
Okay, thanks, Linda. Rachel?
Thank you, Chair. Thank you, Veronica. I just want to clarify with regard to the regulations on DAPOs and DAPNs, or by other name. Who is paying for these orders, notices? Is that in these regulations, or is that to come after?
It wouldn't be covered in the regulations in terms of payment for them. That's something that we want to be considering in terms of kind of the monies that would be available to police for this in terms of bringing these forward. There's also a sense that a number of these orders, there will be, to a certain extent, movement within the system. So in some instances where a non-molestation order is currently being taken forward, or an occupation order is being taken forward, some of that money and some of the funding associated with that will move within the system. If that makes sense, it's something to be, that will have to be looked at in more detail, but not something that needs to be provided for in the regulations.
Okay, thank you. And just one more point on that. Is that going to form part of the consultation that's being launched by the department?
In terms of the funding, there's a section in that the consultation paper about the public and financial impact on which we're seeking views.
Okay, thank you.
Any other members in this group of amendments? Sorry, Linda?
It's just a tiny point. It's an acknowledgement, and just to commend the department and the education department for adding in the issue of preschools that Sinead Bradley had raised at Thursday's meeting. I think that was a good piece of work, and to get that done so quick.
Okay, so Veronica, in terms of those group of amendments, I think the committee, I haven't taken a formal position on them, but I think we're there in terms of having an agreed position on that. That's why I don't feel the need to labour those aspects of it, but the committee will formally take a position on them shortly after we deal with the legal aid aspect of it. So
thank you, that's helpful.
I appreciate the department having listened last week and I think has reflected the will of the committee in terms of those discussions, and we can make progress on that basis, so thank you for that. So if you're happy, Veronica, we'll move on to the legal aid aspect now. And Stephen, I think you're going to just take us quickly through the proposed amendments.
Okay, Chair, John's actually been working with the draftsman, so I'm going to ask John to lead the committee through that.
To begin with our proposed new clause 27, this would provide for a financial eligibility waiver for victims of domestic abuse to enable access to legal aid for them to defend an Article 8 application being brought by their abuser. It would replace the clause 27 currently in the bill, and it differs from the existing clause 27 in a number of important ways. The committee will recall the department has expressed concern that the current provision could give rise to an increase in litigation, to the complication of litigation by an increase in the number of allegations of domestic abuse arising in such circumstances, and by, in particular, by the misuse of the waiver by abusers to perpetuate their abuse further through the courts. These concerns arise principally out of two features of the current clause 27: the lack of an evidentiary test that the director can apply to identify a victim, and the ability to use the waiver to bring proceedings as well as to defend them. And so the replacement clause 27 addresses both of those issues by limiting the circumstances of the waiver to defending applications brought by their abuser, and by adding provision for guidance under the Legal Aid in Corners Courts Act that would identify the evidence that would enable the director to be satisfied that a person was in fact a victim of abuse as intended. The replacement clause 27 also would limit the application of the waiver to representation lower, rather than currently as provided for advice and assistance and representation generally. This is because, on the one hand, advice and assistance is not generally required in circumstances where someone is seeking to defend an application that has been made to the court. They'll move immediately into representation lower, and because we believe that representation circumstances can better be provided for in respect of representation higher through existing powers that the department has to protect people in those circumstances. Would you like me also to describe clause 27A now, or do you want to do them separately?
No, feel free to go on to 27A.
So 27A is a clause modelled on the department's previous amendment A26, which is to provide for a report on the legislation and other steps that might be taken to further protect victims of domestic abuse in the course of Article 8 family proceedings. It anticipates that further regulations might be required under the Access to Justice Order for that purpose, or that some other course of action might best serve the purpose. It provides a timetable for that report and defines its purpose as either reducing, including in specific circumstances, to nil the financial costs incurred by a client in these circumstances, and also preventing, so far as reasonably possible, the undue use of the court system to bring proceedings in an abusive manner against qualifying persons. The remainder of the provisions in Clause 27, proposed Clause 27A, relate to definitions of the various terms used there: qualifying proceedings, relevant client, abusive person, and so forth. Part of the intention behind this revised clause is to deal with those limited or exceptional circumstances where it may be useful to extend the application of the financial eligibility waiver provided for by Clause 27 to cover, for example, the bringing of applications in certain limited circumstances, or to extend it otherwise as may be necessary. But it's also intended to look at issues such as the use of the courts by their current powers to prevent abusive applications being brought.
Okay, thank you, John. That's helpful. A couple of quick questions just to clarify for my benefit. The amendment then 27(1)(a)(b). So see, in terms of the director being satisfied, and that's obviously an issue that I think all of us struggle to try and set out what the parameters are. What would the parameters be here for the director in reaching a determination as to what is a victim of abuse?
The intention would be that under what would be Clause 27(2), guidance would be issued by the department that would set out in what circumstances the director could be satisfied that someone was a victim of abuse. The form of that guidance, we imagine, would essentially amount to a list of forms of evidence that the director could take as evidence that a person was in fact a victim. We've discussed previously the fact that the clearest of such evidence that would be available would be evidence that a person had been convicted of a relevant offence, or of an offence aggravated in the way anticipated by the bill by domestic abuse. There might be other forms of evidence, for example, where there's been a finding of fact in a court that a person has engaged in such behaviour, or some other documentary form of evidence that could be set out that would enable the director to be certified. What we'd like to be satisfied. What we'd like to do is to go and explore with stakeholders what forms of evidence might best be used for that purpose, and to explore the consequences and risks of including each of those within the definition. Essentially, there's going to be a balance to be struck between, on the one hand, limiting only to convictions where the director can be absolutely certain that the person is a victim, and to admitting other less definitive forms of evidence to stand, which broadens the application of the waiver to more deserving parties, but with each step that's taken in that direction opens up greater risk of its use by people who are not in fact victims of abuse and may in fact be abusers. The intention would be to explore that issue fully with stakeholders and to come forward with proposals in the guidance as to what balance would at the end be struck between those two countervailing considerations.
And would that guidance have any statutory underpinning?
The intention is that 27(2), as would be part of this bill, would provide that statutory underpinning. So our concern at present is that the department could, of course, issue guidance to the director, but without making express provision in the bill that anticipates that guidance coming forward. A challenge may be made that we were unduly fettering the discretion that had been granted to the director by the primary legislation. By putting it on the face of the bill in this way, we ensure that guidance is more robust, and because it's anticipated by the bill, it's not as vulnerable to challenge at a later stage.
And would it come through the Assembly in any way via regulation for that list?
The intention would be, the intention would be that we would consult on the guidance and would therefore come before the committee for consideration as part of that process. and we hope that we'll be able to work with the committee on its development as the department develops its proposals.
Okay. In terms of the reference in 27(1)A around representation and the lower courts, just elaborate for me, as the bill is currently now in place, it cites advice and assistance or representation. So if you can just comment on your wording vis-a-vis the current wording.
The two key differences with our wording are that, firstly, as you observe, advice and assistance wouldn't be covered by the waiver, and secondly, that representation in the higher courts wouldn't be covered by the waiver. The reason that we seek to exclude advice and assistance is that the circumstances that are anticipated here is that an abused person is seeking to defend an application made by their abuser. In those circumstances, they're not in need of advice and assistance. They're in need of assistance and representation, which is provided under a representation lower certificate. So advice and assistance isn't relevant for the abused person in these circumstances. The reason that we seek to exclude representation higher is that by applying this waiver directly to representation higher, we step on the toes of provisions that are already in place that allow the director to make a discretionary basis disregard incumbent capital for the purposes of ensuring equitability, which we consider to provide a superior protection in the circumstances where they're required. So the circumstances that would arise might include, for example, a person being granted the waiver to defend an application for these proceedings brought in the lower courts. Those proceedings then transferring to a higher court, and then the director would then be in a position to use his discretion to ensure that a person who had the protection of the waiver in the lower courts was not less favourably treated when moving into the different statutory realm of representation higher, and could manage to ensure their protection was maintained. So we would essentially like to make use of the existing protections rather than seek to apply it in the very limited circumstances where representation higher would be needed.
Okay, so the wording you provided, representation, that includes, for my benefit, an action is being taken against a client, the respondent, to go to their solicitor and to get assistance right from the start of proceedings,
Yes.
including then once you're in the family court.
Yes, so representation lower covers all of the help and assistance and representation that a person needs in the course of ongoing proceedings. Advice and assistance is intended to cover those circumstances where proceedings are contemplated only. So you might go and seek advice and assistance as to whether you ought to bring proceedings against another party. Where proceedings have already been initiated, where you need to defend them, representation lower is the system under which you get the help that you need in those circumstances.
Okay. For completeness, let me just pick up on the other amendment. In terms of the report that would set out the department's proposals, and it makes clear that that would be by way of regulations under the Access to Justice Order. Again, in terms of the oversight of that, would that be by way of an affirmative or a negative resolution of the Assembly for those proposals?
Chair, those regulations are by negative resolution, but the report has to be laid before the Assembly. So you get two bites of the cherry, essentially. You get the report, and then any subsequent regulations would be laid before you. So you would have two bites of the cherry.
And it's solely confined to the Article 8 aspect in terms of that amendment that you would be reporting on, so it wouldn't be on wider aspects of legal aid in respect of other offences under domestic abuse.
We haven't been able to identify the circumstances in which it might be necessary to go wider at present. I think if we start the policy work to look at the support that might be necessary for victims in these circumstances, and that suggests that in fact support is needed in other areas, I would expect that the report might comment on that, to let the committee have the benefit of the evidence that we have to that effect. But what's contemplated directly is looking at proceedings involving children and proceedings involving victims of domestic abuse, and seeing what forms of support are necessary in those circumstances.
Okay. And is it intended then that that would replace Amendment 27, or sorry, yes, the new clause 27, that once you get to the point that you're laying down this report, that would supersede?
That's one potential recommendation the report might make. I wouldn't necessarily take the view that that will be automatic. I mean, among the things that report will want to look at will be the operation of Clause 27 in practice. So one of the things that we're currently seeking to establish within the Department, within the Legal Services Agency, is the arrangements that will be necessary to monitor and evaluate the operation of this clause to determine whether it's helping the people we hope it will, and what the cost implications are, to look at some of the potential unintended effects of it, so that we will write the report with the benefit of evidence about what the effect of Clause 27 has been. And a key thing will be not to prejudge what that evidence might tell us. It may tell us that Clause 27 has been successful. It might tell us that it's been successful to a limited extent and that we could build on it. It might tell us that it's having negative impacts and needs to be modified or indeed replaced, as the case may be. But the report is intended to give us time to gather the evidence about what the best course of action is, and then to do that. And as Stephen says, whichever proposals the report recommends and whichever legislation the report recommends will come back to the Committee and the Assembly for their proper consideration in due course.
Okay, thank you. Rachel?
Thank you, Chair, and thank you for that. No surprise to you, have a number of questions. I'll start just working backwards, just picking up on what's already been said. In terms of the proposals here with regard to only the lower courts, and it would be only representation, stated that would also include advice and assistance. Are you stating that your amendment, as it stands, the proposal includes advice and assistance and representation at rep lower, including pre-proceedings?
Okay, but just to be clear about this, advice and assistance and representation lower are two of the three civil legal aid regimes that exist within the legislation. Advice and assistance is used for the provision, as the name suggests, of advice and assistance to an assisted party in circumstances where either there are no proceedings contemplated or where proceedings are contemplated only. It ceases to apply in circumstances where proceedings have been initiated. And so representation lower is the scheme by which assisted parties receive the advice, assistance, representation and other help that they need from a lawyer to enable them in the course of ongoing proceedings. Because what we contemplate here is that the waiver will apply in circumstances where a person is seeking to defend an application that's been made against them. It will apply only in circumstances where such an application has been made, and therefore the relevant scheme is the representation lower scheme. It doesn't limit this form of assistance or help or representation that the person will get to representation only. It just demarcates that the scheme under which they'll get the assistance will be their lower one.
Oh, okay, so that's not my understanding from speaking with members of the legal profession in the last 24 hours, what this amendment would, the principles of the amendment would seek to do. So just to clarify, if I'm going to a solicitor for child contact, and I appreciate that with regard to the representation of the lower courts, this is all predicated on somebody defending. But if we take that aside, in terms of going to a solicitor for child contact and you're initiating proceedings, if there was a part in an amendment saying that it only had to deal with whenever you're defending, i.e. you're the respondent in this, that pre-proceedings such as mediation, which is a requirement to solicitors, in my understanding, to offer mediation to couples or parents or ex-partners on child contact, that would not be covered in the Department's amendment as it currently stands.
No, so as it currently stands, the Department's amendment would allow for the application of the waiver only in circumstances where an application had been made to the courts for an Article 8 proceeding by the abusive partner. It wouldn't apply to the provision of advice and assistance for other purposes.
Okay, so would you see that being a bit of an unnecessary barrier? to a lot of people who would be seeking advice and assistance, given that they would have to front the costs of that, but then the waiver may or may not step in if there was proceedings taken against them only?
But the important thing to remember is advice and assistance is £88. It doesn't cover mediation, so I'm not quite sure in the mediation point, because there is currently no legally aided pre-court mediation scheme. It's something that we're looking at in terms of our early intervention separating parents action plan, but there's no current legally aided pre-proceedings mediation, and advice and assistance is £88. So it covers a fairly narrow set of circumstances, as John indicated. The kinds of issues that, if proceedings are being taken against you, will be covered by the Rep Law certificate.
And part of the purpose of having 27A in as an additional amendment is that we can look beyond the immediate purpose of clause 27, which is to assist in these circumstances where an application is being brought against an assisted party. We can look and see what other additional forms of support might be useful. So if mediation pre-proceedings or pre-litigation is anticipated, what effective forms of support can we offer to people to enable them to explore that route? It might be that a financial eligibility waiver for advice and assistance could be the most useful form. It may well be that some other form of help is more helpful in those circumstances. And one relevant consideration to bear in mind is that a financial eligibility waiver doesn't give anyone access to free legal aid. It gives them access to legal aid subject to their making a financial contribution. And in circumstances where a person is above the financial eligibility threshold and therefore in need of a waiver, their contribution can be very significant, especially in the context of advice and assistance, where in the first instance the costs are limited to £88 for the application being made to the LSA. So, all of which is only to say, in the course of looking at this report that is intended to be brought forward under what would be clause 27A, this is an issue that can be explored there to ensure that we're offering the best form of protection in those circumstances.
And with respect, I would make that argument for its inclusion at this stage, for the best possible support for victims at the earliest possible stage. I would be making the same argument. In terms of the regulation only applying to an applicant for the lower courts, you've limited it to lower courts and have briefly explained that. But in terms of cases where there is implacable hostility between A and B, for example, it's my understanding that these cases would be referred by the Rep Lower to the Rep Higher by way of the Family Care Centre, or indeed straight to the High Courts. So would the Department's amendment mean that the waiver no longer applies in that case?
That's correct. So when the case was transferred from the Family Proceedings Centre to the Family Care Centre or to the High Court, the waiver would no longer apply, and a separate they would be under the terms of the Representation Hire scheme. So there are two potential circumstances that arise there. One is where a person has a waiver for the lower courts, and they move on moving the Representation Hire scheme, which is a different financial eligibility test. They may find themselves in a position of being financially eligible and no longer in need of a waiver. Okay. In the alternative, they may transfer up to the higher court and find that they're still outside the financial eligibility limits for representation hire. In those circumstances, the waiver won't apply to them. And the intention is for us to work with the LSA to explore the application of the existing discretions available to the Director under the Financial Provisions Act, which include his discretion to disregard capital or income for the purposes of determining a person's eligibility and for assessing the size of their contribution.
Whilst I appreciate that it's in terms of working with LSA to explore an already existing waiver or discretionary power that is already there, can you just confirm that that has not been used?
Well, it hasn't been used to date because the circumstances haven't arisen to date. The circumstances we're talking about are on the transfer of a person who has had the financial eligibility waiver exercised in their favour in the lower courts, transferring to the higher courts. Necessarily that circumstance hasn't yet arisen because the financial eligibility waiver isn't currently in place. But no, to date, it is not. The discretionary power hasn't been used in respect of family cases.
Okay.
And the task that would be in front of us is to determine the circumstances in which it would now apply in the context of the waiver being available at the lower courts. At present, in all circumstances, the protections that are the financial eligibility test for that applies at higher court levels is generally more protective of applicants than that which applies at the lower courts. And what we'll be looking to do is to ensure that situation pertains, that the client is not less favourably treated under rep higher than they would be under rep lower when the financial eligibility waiver is operational.
Okay. I just, in terms of the already existing waiver, because it hasn't been used, it's not, obviously it's not already there because it's not there because, or it hasn't been used because there hasn't been the need to use it with regard to eligibility. It hasn't been used, full stop. So if it hasn't been used, why hasn't it been used? Because I've had many representations made to me, and I'm sure other members have as well, of especially women being dragged through the High Courts on appeals at the cost of, say, 80 grand in debt. So if there is a way of putting a waiver out, it hasn't been used, so obviously that needs to be looked at, but I don't see that to be the detriment of then having this in place as well. But just in terms of complex cases, those involving mental health issues or other serious allegations would be referred to the higher courts again by the magistrates' courts or the lower courts. So the department's amendment doesn't mean, does that mean that those victims can't access the waiver? Just so as soon as that's been pushed up to higher, then there is no waiver for complex or those involving mental health allegations or serious allegations?
Yes, for clarity, when a case transfers from the FPC to a higher court for any reason, the waiver will cease to apply as it would, under our proposed amendment, the waiver would cease to apply as it applies in the representation lower. Again, we'll need to look at what other protections might apply in respect of rep higher and the ongoing proceedings, but the principle would be that the person is not less favourably treated when the proceedings transfer to the higher courts than they are under the existing scheme.
And just to confirm, sorry, go on ahead.
No, I was merely going to add, and of course, the part of the purpose of clause 27A is to allow us to give consideration to what those protections might be, how the waiver might operate at the lower courts, and how indeed a waiver might eventually be introduced in respect of representation higher, if that's the best available form of protection. The intention is not to introduce this and stop here. The intention is to introduce this and then look at what further or additional or alternative protections might be in the best interests of these vulnerable people.
Okay, and again, I would argue that putting it in wider, well, I'm saying wider now, the way it is written at the moment, and then can assess in a couple of years' time also stands. With regard to the publication and sort of getting guidance for the director on terms of what is the applicable information about the commission or alleged commission of an offence. Is there a time scale within the department's amendment of when that guidance would be drawn up and when it would be from? When does the department see this date starting?
The guidance will need to be in place before the director is called on to make his first decision as to the application of a waiver. So when the waiver is operational and someone makes an application, we need to have the guidance in place in advance to allow the director to make that decision in a satisfactory manner. So we haven't put a firm date for that. The intention is to bring it in line with the entry into operation of the provision for the waiver. So
when would that be with regard to the department's currently worded amendment? When do you envision that happening?
Well, that's our first piece of work post the final stage is to start working on that guidance. So, as I said, we can't give you a firm date, but that's the first thing that we would need to do, because as John says, the waiver won't work effectively without it.
Yeah, I appreciate that. So in terms of if there's no firm date, there's no date to working towards, there's no date to have it in, and yet within 27A it's a 2-year reporting requirement to report on the effectiveness of 27 within 27A. So how could you assess that this waiver was working ineffectively and working for victims if there is no firm date when the guidance is in, and then 2 years after the rule is sent, that there would be an assessment done?
Okay, I mean, so we've been working on the drafting of this, and the way the clause 27.2 is crafted is that the guidance must be produced by the department. The department is required to produce this guidance, and we can't simply avoid it by not doing it. And because the waiver doesn't operate effectively without it, in circumstances where the waiver came into operation and the department had not produced guidance, the department would be immediately in default of its duty under 27.2. So the timeline, if you want one for the production of the guidance, is it must be in place when the waiver becomes operational.
Yeah, and I appreciate that, but without, in terms of I'm questioning that the department must produce it, and yes, it's written down here, without a date and a time that it needs to be operational by. How do you foresee a 2-year assessment period within 27A adequately assessing its effectiveness if it's not in place by the time the reporting is done?
Well, in a way, that's the answer, isn't it? Because, I mean, 27A isn't just about reporting on the effectiveness of 27, it's broader than that. But we would need a reasonable period for 27 to be operational. So, as I say, it's the first piece of work that we would need to do. We can't commit to a date until we look at our resources and do the planning. So, you know, once we've done that, we're happy to come back to the committee on that. But we'll need to take a little bit of time looking at the resources we have available, reprioritising our other work, some of which is also of significant priority, and then come back to the committee. I can't give you a firm date today.
But the answer to the question, when will the guidance be available, is it will be available as and from the commencement of the entry into force of the waiver. So as soon as it's operational, there will be guidance to support it. That's what the legislation requires. We can't. There's no circumstances under which this legislation permits us to have the waiver operational and not to have produced the guidance.
Okay, and just to clarify, when does this waiver come into operation?
It comes into operation when the relevant section of the bill comes into operation.
Do you have a date on that?
Again, no, because this will be subject to a separate commencement order, and it'll be commenced when it's ready to be commenced. So, I mean, as I said, this is something that we're prioritising, but we have a whole lot of other things to prioritise too, so we need to look at our resource position. I can't give you a firm date on either issue at this stage, but this will need to come into operation, you know, in a reasonably short time. But I can't give you a definitive date at this stage.
And that is exactly what concerns me with all of this, is that the department has come forward with these amendments and have taken 27 in its entirety. With regard to the eligibility for victims of civil legal aid, has tied it down to only the lower courts, only respondents, and only those whenever you're funding representation. Does not have any forward programme in terms of what is going to be done in the higher courts. We already have something in place and it's clearly not working because it hasn't been used. And it is limiting, restricting part of the court system for victims of abuse. So we're bringing in the Domestic Abuse and Family Proceedings Bill with no indication about what date any of these will be commenced, and no indication for victims of domestic abuse who are currently being trailed through the courts of when this actually comes in, because it is competing with priorities already in the department and to deal with resources, and we don't know when it will be commenced, because it will commence when it will be commenced, because there is no firm date written within the department's amendments as they currently stand. I echo the Chair's question earlier on with regard to how these are being laid. I would have very big concerns that this is going to be done in negative resolution. I don't see this as having two bites of the cherry. I see this must come in as draft affirmative. This is far too important if we're looking at legal aid and support for victims through the court system. The defence case, in terms of having only the client as a respondent of proceedings, if you could outline the reasons for the regulation being worded like that and why it's necessary, and does that then address the concerns that were raised with us last week with regard to potential abuse of this by perpetrators alleging to be victims? Does that allay the department's fears on that?
So you're right to say that the reason that it's limited to people seeking to defend an application is in response to the issue, or the potential issue, of the waiver being used either by people who aren't, shouldn't be entitled to it, i.e. who aren't victims of abuse, or in the worst case, by abusers to make use of the waiver to perpetuate abuse further. Sorry. Yes, that's for exactly that reason. So, given our understanding of the rationale here being to prevent the perpetuation, to mitigate the effect of perpetuation of abuse through the courts by abusers, by limiting only to defending applications, it answers that purpose without opening up the risk of the misuse of the provision by others.
And can you clarify that that addresses the department's concerns on that as it's written?
Well, I think there are risks, and we outlined them in our last session, so in the interest of time, we're not going to re-rehearse those. I mean, any of these options carry risk. This is removes some of the more significant risks, but there are risks that remain, and hence why we want to look through 27A afresh at this in a reasonable time frame. So does it address all of the risks that we identified? No. Does it address the most significant risks? Yes.
Okay, thank you. But it does limits the scope if a victim wanted to take proceedings against their abuser. It only covers those victims when cases are taken against them.
It was our calculation that, yes, that's exactly correct. It allows only for the defending to defend proceedings. It was our calculation that to allow beneficiaries of the waiver also to bring applications would entail too much additional risk relating to the misuse of the waiver, and that on balance, to mitigate that risk appropriately, it was necessary to limit the defending applications, the intention then being to use the proposed clause 27A to explore what circumstances in which the waiver could safely and reasonably be extended to the bringing of applications also, or what alternative protections might apply in those circumstances.
And just to, with regard to that last point and the guidance that's under section 2, surely there would be, within the guidance under section 2, there would be applicable information about the commission or alleged commission that would weed out, to use a bad term, to weed out potential people who are abusing the system in elective proceedings. So you wouldn't actually have a time where you would have less risk of abusers using the system and pretending to be victims to get an eligibility waiver, because the guidance already exists for the Director of Legal Services to decide if that information is indeed applicable.
If we could limit this to where there's been a conviction, then absolutely we can avoid, there are clear circumstances, but our reading of what the committee wanted is there will be circumstances where there hasn't been a conviction for a variety of reasons. So the broader that you go in terms of defining a victim, the more risk you bring in. So, it's a trade-off here. If we limited that guidance in terms of solely on convictions, that would be one thing. But to try and capture all of those who are victims in or who you may see as victims, that brings in additional risk. So that's the key issue there.
Yeah, and that's there anyway because it's within the guidance. But what I'm trying to say is that you've put you've confined it to the client being a respondent in proceedings to try the sort of defence requirement. You've confined that to try and reduce the risk of abusers using the system, but surely within the guidance you would have to have some applicable information about the commission or the alleged commission of domestic abuse in order to weed that out anyway. So do the two things...
Yes, this is the point we're trying to make. If it was a watertight definition of a victim, so if there was a conviction there, that's very clear and there's very clear information, and yes, we possibly could go in those circumstances slightly broader in terms of the types of proceedings, but in order to avoid that interaction between and cut down on the abuse, we could do that. The alternative is we go slightly broader on who a victim is, but then we're creating those other issues. It's the interaction between those two factors that is the issue. So if the guidance is very tightly defined, that's one thing, but we got the sense that that's not where the committee are. But it's the interaction between the two things. You can't look at them in isolation.
I appreciate that, and with respect, there is no committee position on this. So I think this is. I appreciate that you're trying to come back on a number of things that were mentioned by the committee. I'm certainly not looking at any way of having conviction tied to this, but just in terms of balancing that out and having people abusing the system, I don't buy that risk enough to have it written down on an amendment. At all. I think this needlessly restricts the eligibility and actually is creating a very artificial group of victims that may be eligible for this. So I'm just wondering, in terms of numbers, obviously there was a lot of risk in terms of cost, and we still haven't got to the bottom of the double-figure millions that we were spoken to. So I'm wondering if the department does have any sort of financial pressures or costs that would be in relation to your amendment as it's currently drafted?
Yeah, the department's proposed amendment obviously limits the cost because it's limiting the types of proceedings. So we haven't been able to cost that out in the short period of time that we've had, but it would be a more limited cost than the broader amendment, certainly.
We don't have any information on either of those, apart from the double-figure millions, which we still haven't quantified about where that came from.
Yes, because during the normal policy development process, obviously we'd have done impact assessment, human rights impact assessments, business cases. We haven't had any time to do any of those things because this has been a matter of a couple of weeks. So that's part of what we'd be looking at in 27A, looking at those impact assessments, the human rights assessments, business cases for doing other things. But in the very short period of time we've had available, we haven't been able to use those documents, obviously.
Chair, my last point, and let others come in because it could take all day. I appreciate the difference between A26 and A27 and A27A, but I see this as another delaying amendment, and certainly it's not going to be working for victims of domestic abuse that are needing legal aid to deal with child contact orders. It's creating an artificial group of victims, and certainly one that will not be workable for those in the legal profession to help victims, and that is what we're here for, is to assist victims, and this does not do that without the information that we need, and we don't have guidance, we don't know what that is, and it is, as and whenever it's going to commence, we don't have a date there. So I appreciate the department coming back on this, but certainly I can't support the amendment as it's written.
If it's helpful in terms of timings, this is one of the points that you raised. Our proposed clause 27 and the clause 27 that currently stand part of the bill are in the same position with respect to timing. Each of them will come into operation on the commencement of the relevant chapter of the bill. So there's no departure in terms of the proposals that we have from those that currently stand part of the bill in that regard. And just to slightly reiterate, the guidance that's required under our proposed clause 27 will be required in exactly the same timescale. So to the extent that there's any concern about potential delay, it doesn't arise of any of the proposed changes that we propose to make to clause 27. It exists with regard to the current provisions too.
Linda, Sinead, and then Paul.
Just a quick point in relation to the lower and the higher court, and I accept what you're saying in relation to, the protections in the higher court are potentially greater. Is there a halfway meeting point where there could be some kind of an assessment as to whether the waiver that is already in place would better serve the defendant than what we're talking about that would be in place in the lower court, so that it could potentially stay in place if it's going to be the better form of protection? without, I suppose, unintentionally negatively impacting the victim or the respondent. And then just in relation to that definition around that it is only in defence, you know, where a defendant, I have to be honest, my understanding was that we were trying to stop the abuse where people were repeatedly being brought back to court, and those were the conversations we had as a committee. So I would be content with that at this time, only because I have the fear of the further abuse being used if we go outside of that. And I think that there does need to be more work to establish to make sure that that's not what's going to happen, because most of the cases I have dealt with have been cases where people have been repeatedly taken back to court and where they're the respondent. I very seldom find a case of an abused person who is actually taking court proceedings, because in the majority of cases they're so glad to be out of that circumstance. But I have no doubt that there are, like any of these things, you know, the law is so complex and so difficult, and particularly when it comes to family law and children, that there will be cases that I can understand where Rachel's concerns come from, but I think that it needs to be properly backed up with evidence and facts, and that we need to make sure that what we put in place is actually right. So for me, I would be supportive that at this point that it is about the respondent, but that's why I'm actually glad that 27A is there, because we do need to get the further evidence around this to see is there more measures and better measures that could be put in place to protect those who are victims of abuse. We know how the family courts are already used to further abuse, and all of those laws were put in place with good intention and with good scrutiny and with all the evidence and information to back them up, you would like to think. So I just would be concerned about putting something in place without that. So it would be, we may not be able to reach a committee position on this, because it would be my position that we would be, at this point, it would be where the person is a respondent, but that, I certainly wouldn't want it to be limited to that forevermore, which is why I think the 27A is important. But if there's a halfway meeting point in terms of the upper courts, because I share Rachel's concerns around that, around the fact that you could have people going there without any protections, and I mean, it comes back to the same point, and why I very much would have supported this initially is this is about protecting those victims from being further abused, both financially and psychologically. But that whole thing about draining the resource, and it's that further ability to have that financial control and fiscal control over the victim, even whenever they've got out of the circumstance, the relationship. That's it.
Okay.
Thank you, Chair.
Sinead?
Thank you, Chair. I suppose there is no committee view, but also what's becoming more apparent, there's no committee objective in terms of what was to be achieved here. And like Linda, my understanding was that this is the domestic abuse bill, and we were talking to that part of it where the victim is perpetually being weaponised via the court system. And I have taken some direction from some family lawyers on this regard, and I do follow and understand the reasoning behind the 27A as the further piece of retrospectively looking at the data and what happened. But I do wonder, you mentioned in your presentation to us that there was some, I think you said, stepping on the toes of the director's discretion around the discount of capital. And I do wonder at this stage, should we be looking deeper into that? For example, if somebody has had success in a civil order and they then apply, I'm advised by the solicitors that one of the biggest obstacles to them immediately is the fact that their housing benefit, child tax credit is all taken into account, even though that's not actual money in their pocket. So I'm wondering, is the answer to this in that waiver? Is that early piece of work around the waiver the right place to resolve this? Because as it stands, I'm not convinced that 27 is going to have serious effect with our immediate effect. And I do understand that we could go back and refine that further, but there is a very obvious, some low-hanging fruit where we get to help those who will be most affected by that perpetual weaponising of the court. and the fact that money is accounted. I don't know, and also I know there's this appeals mechanism that triggers in the family care centre. You know, all of that has to be taken into account. So I don't know if any consideration's been given to that, or if you anticipate that being in the guidance or in the further piece of work that you intend to do.
That's fine. Yeah, I think, thank you for that. I think that's a neat expression of the intention that we have with these two clauses and their interaction. I think clause 27 tries to do something immediate and directly for vulnerable people who are having this experience of being dragged repeatedly before the courts, to do something right away to help them, and to do so in a way that is limited in terms of its potential risk and unintended consequences. 27A is clearly intended to operate in conjunction with that and to say there are circumstances with which this limited and immediate measure will not help. And we want to go and take the time to understand what we can best do to help people in those circumstances. With particular regard to this business of the operation of the waiver in respect of the higher courts, so where cases are transferred up or where things are appealed to the higher courts, the financial eligibility test at the higher courts allows for the provision of legal aid in circumstances where a person might have a moderate income or some degree of capital in hand. What the waiver would do would be to remove that cap on the availability of legal aid. But what it would also do is necessitate for anyone in whose favour the waiver then operated at that level, would necessitate really very substantial contributions to their own costs in those circumstances. And then especially where a person has capital in hand, for example in the circumstances you describe, where they've had a successful civil order granted in their favour, where they have capital at hand amounting to more than £3,000, the amount of their contribution is going to end up being as much as the full cost of the proceedings, i.e. the waiver won't operate to their benefit at all, even though it applies to them. Which is why we say what we want to do is to go and understand what sort of circumstances these people are in when they're coming before the higher courts and how we can then best help them. And it seems to me that the operation of the existing discretion to disregard capital and income is a more potentially helpful starting point to look for those solutions than it is to try to apply a waiver of the financial eligibility test in these circumstances. But I say these are complex and contested areas of law, and whichever help we try to give, its outworkings will be determined in large part by what happens in the courts themselves and the challenges to the department's decisions and to the LSA's decisions about the operation of these things. It's important to take the time to get them right. So what we say is clause 27 helps now, helps a vulnerable group of people who are in need of support, and we think that the protections that we've sought to introduce in redrafting it help to limit any potential negative consequences of it and allow that early win to be grasped safely. And clause 27 says we will then look and see what further protections can be afforded and how we can go safely into the territory, for example, of allowing applications to be made where circumstances say that that's the best way of resolving the issue, to allow for protections around people who have needed representation in the higher courts. That's exactly the intended operation. And I don't think the fact that there's a 2-year window envisaged for the presentation of a report to the committee might, prevent sensible proposals being brought forward in the light of evidence about the operation of the waiver in an earlier timescale, say, if it's very apparent that there are issues with this operation in practice, or that there are people who are without its help that we could quickly and readily do something for. But what it does do is we hope give confidence to the Assembly that in a reasonable period of time the wider issues can be looked into and sensible proposals to help people brought forward.
Sorry, could I just seek clarification that I take what you're saying on the face of it, that 27 is supposed to be the immediate piece, but for that person who has been disqualified for access to legal aid because they have housing benefit, where is that? That's not there because the guidance isn't there, so it doesn't actually immediately swoop in.
So the waiver will ensure that such a person, when it comes to representation in lower sort of proceedings in the lower courts, the waiver will enable that person to have access to legal aid. And as I say, the guidance is required, Section 27 requires guidance to be in place as the waiver is in place. There's no potential for delay of its operation through that mechanism. So Clause 27, when it enters into effect, will afford protection to a person who would otherwise be unavailable to access legal aid by reason of their income or their capital from whatever source it comes. So they will be protected immediately in those circumstances. What 27A lets us do is to look at other circumstances and other protections that might be available in those circumstances, and then to go further, if we can, to help others and to help people in those different scenarios.
I suppose, just to be fair in summary, Chair, I'll not take you long. I think there is a nervousness in that the intent's there, but it's not on the face of the bill. So given that reassurance when it's not actually there, and then the timeline issue comes into play, so I suppose maybe there just are serious concerns and nervousnesses about that. Thank you, Chair.
Yes, thank you, Chair, and thank you very much for your presentation. Sorry I had to snip out there for question time, so please forgive me. And some of my questions may already have been asked and answered, so please give me grace on that. Can I ask on... We can see what's happening here, because obviously you guys have been very nervous about Clause 27 as it stands part of the bill, and you then want to, for all the fears and concerns that you illustrated last week, you're trying to tighten up a clause that is quite wide in latitude. So you hear today some of the members of the committee, it's not a committee position, but some of the members of the committee are still showing concerns. Do you have another clause there? Do you have another amendment that widens the scope a bit, but still keeps it tight in your eyes?
Yeah, I mean, we were very mindful last week, Chair, that the committee was not keen that we tried to change the core purpose of Clause 27 as it stands part of the bill. So it talks about a waiver. I think what we say, so what we're trying to do is qualify where that waiver applies. We're not changing it from a waiver to some other financial test, which may, I think, as John has hinted, there may be a different financial approach which may be more beneficial. But you know, we're mindful that there is a waiver, a broad waiver in the bill. We're looking about narrowing, removing some of the most significant risks by narrowing the application of that waiver. And Clause 27A allows us to look whether a waiver is in and of itself actually the best way to approach this. And it may be, but equally it may not be. So I take on board Sinead Bradley's points that the waiver won't necessarily be beneficial to everybody, but it's what is already there in the bill. So we're trying to focus it on who we believe the kind of many committee member sentiment it should be focused on, and take away some of that risk, financial and unintended consequences and otherwise. But ultimately a waiver might not be the best approach, which is why we have 27A as well.
Yeah, I'll go on to 27A in a wee second, but just to repeat my question, do you have another plan B there? Do you have another amendment that you could move if you felt that this committee did not like your amendment 27 as it sits?
Unfortunately, no, we don't. This is the amendment that we have prepared based on the discussion last week. So no, we don't have another amendment ready to move now.
Okay, thank you. So can I ask then, see your 27.1.1a, I think, which you said would stand part subsection 2 then, if it was to go forward, where it talks about the client for the funding of representation at lower courts in the proceedings. But is that not in contradiction to Article 8 as it sits? Because Article 8 talks about family proceedings, meaning any proceedings under the inherent jurisdiction of the High Court in relation to children. So does that not cover everything, including High Court?
Article 8 proceedings can be brought at the Family Proceedings Centre and can take place at the Family Care Centre and at the High Court. This provision wouldn't contradict that, but would limit the application of the waiver to applications for representation to defend proceedings at the Family Proceedings Centre only. The reason that'll make two modifications, and through the slide there, but is to make two modifications to what would apply under the current clause 27 in the bill. It would exclude advice and assistance from the application of the waiver, because in circumstances where proceedings have already been initiated, advice and assistance isn't necessary. And it would exclude representation hire from the application of the waiver, because we would like the opportunity to go away and explore what alternative or better protections might be suitable in circumstances where proceedings in the higher court are contemplated.
So whilst you're going away to contemplate and look at that and assess that, and that's quite understandable, you could then have a scenario where someone, a victim of domestic violence, is having to defend in the low court, and then for whatever reason the judge then states no, this has to go to high court, and then whilst the clause in the bill as it stands will kick in at the lower court, then that waiver would be removed at the high court. Is that correct? Is that your understanding?
Yes, the waiver would. That is correct. Essentially, yes, the waiver would cease to apply on the transfer of the case from the lower court to the higher court, either the family care centre or the high court itself. Our intention would be, assuming that the waiver ends up part of the bill, is that we would look to use existing powers that the Legal Services Agency has, or the Director has, to ensure that people aren't disadvantaged by that effect. The application of the waiver in respect of representation hire is an imperfect solution for someone seeking to defend proceedings in those courts, not least because of the size of the potential contributions that those people make to their own costs. So what we want to do is to say, is to look at circumstances where a person who benefits from the waiver in the lower courts and finds their case transferring up to a higher court can be appropriately protected in those circumstances. We're not sure that the waiver cuts it in those circumstances, frankly.
But you say about existing powers in that regard, but those existing powers has never been used to protect people in the past, ever?
And indeed, they haven't been in the past. These circumstances haven't arisen because there is no current waiver applying in the lower courts to transfer up. This will be a new circumstance.
But do you know how many? Do you know how many numbers or what percentage of family proceedings at lower court goes to high court, and where this requirement may well be met, whereby someone doesn't qualify for legal aid?
It's a very small. It's a very small number, Mr. Frew. We don't actually have that information, but it's John.
Sorry, I don't have the information. It's just not to get something Steve says. There's an appreciable fraction of these cases that are transferred up to higher courts, either by reason of complexity or implacable hostility between the parties. So it's not an irrelevant question. I mean, we suggest that it is. It's just that in that minority of cases that transfer from the FPC upwards to a higher court, we want the opportunity to look at what better protection might serve in those circumstances. As I say, there are powers there that can be used in those circumstances, and they haven't yet been exercised because we haven't yet had a case in which a waiver has, a case involving a waiver has moved up. But as I would say, just to reiterate this point, because I think it's important in respect of the application of a waiver in the higher courts, a waiver for the financial eligibility test doesn't give you free legal aid.
Nope.
It gives you legal aid with a contribution.
Yes.
And the size of that contribution when you're in representation higher can be really very significant indeed. And in those circumstances, we feel there may be something better we can do for these people than to replicate the waiver. And we'd like to go and look at that.
Okay, and I get the reason why you have now proposed two amendments, 27 and 27A, and you have listened to the committee meeting last week, whereby a number of us had said we like the idea of a report within 2 years. But then can I ask the question, why are we still limiting it to Article 8? Now, are you telling me that there's nothing else in legislation that needs to be covered with regards to domestic violence setting and indeed children, other than Article 8 of the Children's Northern Ireland Order 1995?
So Article 8 of the Children Order covers proceedings involving disputes between people with parental responsibility about the arrangements for the residence and contact about children. The other proceedings, the other major branch of proceedings that takes place under the Children's Order would be public law proceedings, those involving Article 50 cases about the potential taking of children into care and other protective steps that are taken by social services. So as we view it, the issue here is disputes between parties, private parties, about the way in which children are looked after, being a medium for continuing abuse, or being linked to issues of domestic abuse generally. And so the clause 27A, as it's drafted, essentially tasks the department with going off and looking at the conjoined issues of domestic abuse and proceedings about private law children's order proceedings, and to come forward with recommendations to ensure that abused parties are appropriately represented in those circumstances.
Yeah, so Article 8 covers... Article 8 covers contact orders, residence orders, prohibited steps orders, specific issue orders.
Yes.
Are you telling me there's nothing else, order or otherwise, that goes through court with a conflict between two private people, children involved, that shouldn't be looked at in your report within the 2-year period?
No. No, I mean, and as John said, there will be some of these cases, because of the acrimony, will lead to public law proceedings
Yes.
under Article 50, but that's between the state and the parents. It's not between between the parents. So in terms of issues between the parents, as far as we're aware, these are the only types of proceedings. Now, it doesn't mean that this doesn't preclude that if something else comes out during discussions, we can't look at it. But in terms of what we have a statutory obligation to look at, it's Article 8 proceedings, but as I say, it doesn't preclude looking at other things, but we're not aware of anything else.
Okay, so I am mindful of trying to keep it within scope and limit, and that's why I'll concentrate only on the Children's Northern Ireland Order 1995. But are you saying to me that Article 5, 6 and 7 around parental responsibility is nothing to do with the two parents? Article 4, child welfare?
I think all of these types of proceedings are linked. I think we've highlighted Article 8 in particular because it's what the current Clause 27 in the bill does. It's what our new Clause 27 in the bill in response to that would do, and it is the main focus for these disputes. But to be clear, if we're looking at Article 8 proceedings involving families in which there are allegations of domestic abuse, we would inevitably also be looking at linked proceedings involving children in the courts and the experience of those. So it's not so much that there's no other relevant court proceedings that we might want to consider. It's that that Article 8 is our focus.
But you're actually...
It's the main focus of these disputes.
Yeah, but you're actually,
Sorry.
in 27A, you're qualifying the proceedings to Article 8 alone, and only Article 8. And I simply ask the question, why? Because even Article 13, the change of a child's name or removal from jurisdiction, Article 15, orders for financial aspect to children, Article 16, family assistance orders. You have a whole range of articles within the Children Northern Ireland Order 1995. So I'm asking the question, should we be removing the Article 8 order in subsection 4 with regards to qualifying proceedings and add and insert the Children Northern Ireland Order 1995 in its entirety?
I mean, I think that would not be an unreasonable. I mean, I think we could look at that fairly quickly. I don't think that's unreasonable. I think 95% of the effort is going to be focused on Article 8 because that's where the cases are. Yeah. But I take your point. We might inadvertently be precluding some other issues. So
I think. I'm sorry. I'm now thinking aloud. If you'll indulge me slightly, to widen into the Children Order in its entirety would also draw in public law proceedings as well as private disputes, which seems to be not wholly germane to what we're trying to achieve. And I think straying beyond children and family context under Article 8, I'm concerned about what else it might then draw in. It risks us moving into areas which we haven't yet actually considered, or that indeed the Assembly hasn't envisaged might be part of this process.
But you're only reporting. You're only reporting. You're not acting.
No, indeed.
So what would be wrong? What would be wrong with assessing and reporting on the whole Children's Northern Ireland Order 1995? And you can report to say that it would be a bad idea to include Article 15, 16, 5, 7 and 8, or sorry, 5, 7 and 6 within the scope of the waiver.
Yeah, I mean, I think subject to our discussion with the draftsman and the Minister, I think that's something that we can look at. I think in terms of effort, we would be focusing our effort on Article 8 because that's where the bulk of proceedings are.
Or at least in private family law.
Private family law. But take your point. So if there's a way that we can craft it without making it so broad that it's unachievable, then we're happy to look at that. So we'll take that away. I wouldn't want to give you an answer now because we need to have a few discussions first.
I understand. I thank you very much for that. Thank you.
We're going to have to adjourn with Justice question time, so we're going to suspend and then we'll reconvene once the Justice question session is over, because we need to complete this piece of work. So folks, if you can be available in 45 minutes time, we'll start again at 3, just after 3:30. Okay, meeting adjourned until 3:30.
This is the Northern Ireland.
Okay, folks, welcome back to the meeting that was adjourned to accommodate the Justice oral questions. Hopefully the folks down the Castle are with us in the audience.
We're told 3:30.
Just checking, I don't see them. Listen. Okay, I'm just checking to see then if folks are there. Folks, I just have a blank screen in terms of the officials. I'm not sure if you can hear us.
Case for Glasgow.
Okay, folks, apologies for this. Just 1 second. We'll see.
Oh, they were coming back, Chair, did they?
Okay, that's perfect because they're not showing up on our screen at the minute. Okay, thanks. Okay, thanks, bye. They're going to ask them to log off and relog on again.
Okay. The wonders of modern technology.
No, switch it off.
See if the officials are able to come back into shot now. No. Sorry folks, just give us 1 second, but we are broadcasting live, just for the benefit of members. Excuse me. See while they're waiting. Let me dispose formally of the other group of amendments then, and then we can come back to the civil legal aid. So, members, in terms of the department's amendments then around information sharing with schools, protective measures for victims of abuse, training, independent oversight, reporting on the operation part, 1 of the Act. Members content with those areas. On the guidance aspect of it around the Northern Ireland Courts and Tribunal Service, has any members any view around that, or are you relaxed in terms of the Department's amendment? I've no strong views on it. Rachel?
I would rather that it was on the face of the bill. I'm not too sure, especially because it's in the training. I don't see the reason for it not being within the guidance.
Linda?
I accept their explanation for it, that in the training it's about an action, and in the guidance it's about giving advice to themselves to do something. So I accept what they're saying, but I mean, I don't have a very strong feeling about it. I accept their explanation. However, if other members are feeling very strongly that it should be there, I'm happy to support the members and give a committee view that we would take it in.
Sinead?
Again, no strong opinion. I did take the department's explanation, and perhaps it's good drafting, you know, not to have it there, given that it's not like the training. It was a distinctly different thing. You know, I could see the rationale there, so I wouldn't be pushing for that.
Okay. Well, I'm accepting of the department's position around this one, given the explanation that they have given in respect of it, but I appreciate, Rachel, the point that you're making to it. So, for members content, then we'll accept the department's amendment, have it noted. Rachel, your preference was to keep it on, but we'll proceed on that basis. Okay. Then there was the amendment to clause 38, and that was in respect of the bringing clause 31 into operation the day after royal assent. That would enable the appointment process for independent oversight to be established ahead of the offence coming into operation. Again, to me that was a positive amendment brought forward, and members content that the committee would support that. And also then the long title and the short title of the bill in terms of those changes.
Yes.
Okay, so that only leaves the civil legal aid, so let's check to see if officials are able to join us again through the broadcasting facility. So I'm not sure if officials can hear us because the screen is being blank at our end.
Their end, I think, rather than ours, actually.
Right, okay, well.
Chair, it's the department again.
Yes, we can see and hear you now, if you can hear us, yes?
Great, thank you.
Okay.
Apologies with issues getting in.
No, you're okay. One of those things. Just a couple of questions that I wanted to tease out. Is the mediation a requirement before court action is taken?
No, Chair, not in Northern Ireland. It isn't. It is in some other jurisdictions, and that's one of the things that we're looking at as part of our private family law action plan, which the committee got a written briefing on a number of weeks ago. But mediation wouldn't be appropriate anyway in cases of domestic violence. So short answer is no, it's not currently practiced in Northern Ireland, and it wouldn't be appropriate in cases of domestic violence anyway.
Obviously this is tied into the bill and the new offence that's being related, so is that the same for where it comes to psychological, financial, the coercive control offence that is being created?
My understanding, Chair, we're at an early stage at looking at mediation as part of the private family law action plan, but my understanding from England and Wales and the Republic of Ireland that where domestic abuse, however defined in those jurisdictions, is in place or suspected, that mediation is not undertaken. So that's one of the issues that we're looking at as we're developing our future proposals around mediation more generally in private family law.
In terms of then the clause 27 as is currently now in the bill, is it the department's assessment that this covers the intent behind it, that this covers all courts in terms of whether it's the lower court or the higher court? Would the clause 27 currently be applicable to all courts?
Yes, it would, as drafted, the waiver would apply, as I understand it, across the court tiers.
Yeah. And does it remove the financial eligibility criteria in the circumstances that it is currently drafted?
No, it wouldn't. It wouldn't remove any existing powers or discretions that the Director of Legal Services has currently. No.
So, in terms of the financial eligibility, can you just elaborate on me then? It doesn't remove the Director's discretion in these areas?
No, his discretion would still be in place. The issue that would arise would simply be that there would be two separate schemes of protection available to address the same issue. Those two might end up competing with one another, and it would require assessments to be made by applicants as to which scheme of relief to apply for, and what is that type, and it would require then an assessment by the LSA as to which scheme ought to apply in which circumstances. I think what we'd like to do is to remove the protection that the current 27 would afford in these circumstances and to replace it with a scheme of protection that's been designed to best meet the needs of vulnerable people in these circumstances. As we've said, I think our suspicion or our strong view would be that the waiver is probably not the best way to try to help these people, and we'd like the opportunity to explore what better form of help might be available, probably focused to some extent on that discretion currently available to the Director.
Okay. Is there any other queries members have then, or from the officials around this? Can I just ask finally, in terms of the commencement of these powers, whether it's the currently clause 27 as in the bill, or if it was clause 27 by way of your amendment, when would you normally commence these? If you were to put on a commencement date for it, when would you normally seek to have that coming into effect?
Yeah, commencement orders, Chair, usually depend on the nature of the provision, because usually there's work to be done before something can be reasonably commenced. So you would normally make sure that that work is done, and then you would commence the provisions, unless you need, to commence particular parts of a clause. So there's no hard and fast rule, and as you'll see with our proposed clause 27A, because there's a 2-year time limit, we're proposing to commence that as soon as the bill gains royal assent. That wouldn't be appropriate for clause 27, because obviously that guidance that we talked about in the earlier session needs to be in place, and that's something that we are prioritising, but that would need to be in place for that provision to be workable. Otherwise, we're into all the kinds of issues that we described during the last session last week.
And maybe Veronica can just guide me on this one. When do chapters 1 and 2 of the bill become operational?
When will they become operational?
Yes.
Those, broadly speaking, will be brought into force when the domestic abuse offence is being brought in.
Okay, and that'll be brought in by way of order of the department?
It'll be a commencement order. Typically, you will either have provision that something comes into effect on royal assent, or it's by commencement order. And on royal assent, you would only bring in those things that can operationally and effectively come into effect at that time. The majority of provisions would be brought forward by way of a commencement order is a typical way for doing this.
Okay, and that's how this bill is drafted, that chapters 1 and 2 will be brought in by way of a commencement order?
Yeah.
Okay. Linda Dillon?
I think we probably need to just remember back to some of our earlier conversations, even if you consider our conversations with the Chief Constable of the PSNI, and they have said that it will take a period of time, potentially up to a year, for their staff to be trained in relation to this offence. So, I mean, if you were talking about that and I'm not asking for you to give us dates, because I know you can't in relation to the guidance, but I would like to think that the guidance will be in place well before that period would be up, and if that's the case, then the guidance will be in place before this will be used against anybody, in terms of the PSNI actually using this legislation whenever they're making a case against a perpetrator. Would that be fair to say?
The intention is that clause 27, like the rest of chapters 1 and 2, will come into force on the appointed day in the commencement order alongside the domestic abuse offence itself. So when it'll all become operative simultaneously. I mean, it makes little sense to bring clause 27 into operation in advance of the creation of the domestic abuse offence, because there will then be no domestic abuse offence to which to tie it, if you see what I mean. So the commencement of the various provisions will be simultaneous.
Sinead?
Just wondering, Chair, are there any examples anywhere where you can really tighten down on when a commencement order must be enacted by or presented by?
In terms of, I mean, ordinarily, I mean, as John said, there would be a sequence for things, because there will be some, you know, the bill is interrelated, or most bills are interrelated, and there are particular bits that it can only really be effective once other bits are commenced. So usually commencement orders, unless, as Veronica said, there are particular reasons to commence something on royal assent, usually it's via commencement order, and usually there aren't other mechanisms for specifying particular times, so it would be unusual practice, you know, unless there's a very, very specific reason, as we have proposed for Article 27A, because it sets the clock ticking in terms of the 2 years would tick from the date of royal assent. So there's a good reason to commence that immediately, because otherwise we're giving ourselves undue extra time. We are controlling the timetable rather than the legislation.
Okay. Any other points of clarity members need? If not, then we'll need to, as a committee, try and consider this in a little bit more detail, but at this stage, can I thank the officials for providing us with all of that information? It's been very helpful, so thank you.
Thank you.
Thank you.
All right, thank you. Okay, members, we will ask the bill clerk to come and join us and go into closed session and then back into public session just to finalise proceedings.
Committee Room 30. This is the Northern Ireland Assembly.
Okay, members, just to complete our work on the further consideration stage amendments, in respect to clause 27 that is currently in the bill following the consideration stage, and also in respect to the Department's proposed amendment at further consideration stage to a new clause 27, that the committee would put forward an amendment to both of them in respect of commencement being associated with and tied into the commencement order that would give operational effect to chapters 1 and 2 of the bill. So in terms of members in respect of this, members opposed is Linda, Emma and Gemma.
To the clause as it is on the face
of the bill. And those in favour of that commencement being applied to clause 27 of the bill are Sinead, Doug, myself, Paul and Rachel. And then in respect to the proposed amendment by the Department to clause 27, all members present are in favour of a commencement being associated with chapters 1 and 2 coming into operational effect via a commencement order. Okay, so members are agreed with the committee position in respect of that. Okay, members, can I thank you for your time and patience in trying to work through this particular issue, and the further consideration stage debate will take place in due course. Thank you, members.
This is the Northern Ireland Assembly Committee